special counsel Jack Smith, as part of his criminal investigation into former President Trump, served a subpoena on X, formerly known as Twitter, back in 2022, demanding the private communications of Donald Trump on that platform, apparently direct messages that he might have exchanged. We don't know the specifics of what was sought or what was provided, but what we do know is that Twitter tried resisting the subpoena. And in particular, what they were objecting to was the fact that contained within the subpoena was an order to Twitter not to disclose to Donald Trump or to anybody else that the subpoena had been served. And Twitter's argument was they have a First Amendment right to communicate with their users and to notify their users that they're being compelled to turn over data about the users to the government because there are certain objections, such as executive privilege or attorney-client privilege or other legal objections that only the user has standing to raise. And by denying the user the knowledge that their accounts are being penetrated in, investigated in, gathered and turned over to the government, they deny the user the ability to assert their legal rights. And that's exactly what happened. Jack Smith succeeded in convincing a court to constrain Twitter from advising Trump. Trump had no idea that his private communications were obtained. And he only discovered now, when the rest of us did, with the emergence of these court documents. And this has become a growing abuse. We talked last night about how the January 6th committee did the same thing. They issued subpoenas to various banks and telecom companies to obtain the private data about people who were found to have done nothing wrong other than obtain protest permits to protest in Washington over the 2020 election and the integrity of it. So they targeted these people for exercising their First Amendment right to petition the government for a redress of grievances, and then blocked them from learning about these subpoenas. All along, I questioned the constitutional authority of the January 6th committee to convene those hearings because we have an executive branch and a Justice Department that is charged with conducting criminal investigations. What really happened there is that Merrick Garland did not want to bring sedition charges or treason charges. And the January 6th committee was an effort to run a parallel criminal investigation led by Liz Cheney, in reality, and Nancy Pelosi, that was designed to put pressure on Merrick Garland to bring those charges, which he finally did. The only reason, the only justification Congress has for investigating American citizens, and this was determined by Supreme Court cases during the McCarthy era that found that Congress had overstepped its bounds, McCarthyite committees that overstepped their bounds in investigating Americans for their political views, is number one, if the investigations are necessary for the enactment of new laws, so in support of congressional lawmaking authority. So for example, if Congress wants to enact a new law about pollution, they have the right to compel corporate executives to testify before their committees and obtain documents so that they can better enact laws. That is in support of their lawmaking ability. That is a legitimate congressional investigatory basis, and that obviously was absent from the January 6th committee. They didn't even have a pretense of attempting to use the committee's investigation for lawmaking purposes. And then the only other valid justification that Congress has for investigating American citizens is as support for its oversight responsibilities of the executive branch. There was a little bit more validity to that claim that they were convening the January 6th committee to exercise oversight over the Trump White House in connection with January 6th. But the reality was that was not really at all part of what they were doing. They were very focused on what members of the American public were doing in connection with these protests. The extent to which they talked about Trump was to condemn him. But that investigation was never aimed at legitimate oversight. It was aimed at running a parallel investigation. And as part of that, they not only abused their power by convening, they abused their power by subpoenaing American citizens based on no facts other than they had protested legally, and then also ordered these institutions from whom they were demanding information to keep secret the fact that they had done so, preventing these American citizens from also exercising their legal rights to object. We had obtained some of those subpoenas that contain these secrecy clauses, which we published and reported on in 2021. And all of this, again, comes from the legal framework that was created after the War on Terror, when they scared Americans into believing that the only way they could keep us safe was by instituting an authoritarian framework and claiming all sorts of domestic investigation powers that previously were considered radical and unthinkable in the name of stopping terrorism. And one of those was that under the Patriot Act, the FBI had now the right to issue what are called national security letters, where they don't have to issue subpoenas, they don't need judicial approval. They could just send demands to private institutions and not only demand those institutions turn over data about American citizens to the FBI without a subpoena or without a court process, but they're also entitled, and often do, put a gag order on those institutions, just like Jack Smith prosecutors did on Twitter, to prevent the people about whom they're gathering information from even learning that they're being investigated that way. That's what makes all of this, I think, so disturbing. Now, there's one part of what happened here that is almost humorous if it weren't so revealing of all kinds of abuses of power. And I think this hasn't yet got a lot of attention. We know, for example, that the media in the post-Trump era has abdicated their journalistic function in the name of doing everything and anything to stop Donald Trump. They lied about the Hunter Biden laptop. We don't need to go all through that, but we know that the corporate media has essentially repudiated and renounced any limits on what they're willing to do in the name of stopping Trump. The US security state has done the same. Big tech has done the same. They censored stories incriminating to Joe Biden in the run-up to the 2020 election. But one of the things that has gotten a lot less attention than it deserves is the extent to which the judiciary has also been contaminated by this obsessively anti-Trump fixation, or whether they're susceptible to pressures inside liberal culture from colleagues, from friends, from family members to ensure that they always rule against Trump. If we're going to convict Donald Trump, we want it to be a fair trial, not because a judge is too scared to issue a ruling in his favor. I talked often about how that's what a big part of what happened at The Intercept was. We did a lot of reporting against Hillary Clinton in the run-up to the 2016 election. And the liberal editors of The Intercept, who work in Manhattan, who live in Brooklyn, who have to function in liberal circles on the East Coast, spent years being accused of having helped Trump win. And they were determined not to do that again in 2020 by allowing me, for example, to publish incriminating stories about Joe Biden. And I watched them abdicate their judicial or their journalistic duties because they were fearful of being stigmatized and scorned. Social scorn is a big driver for humans. We crave social approval. We're social animals. We instinctively want to avoid stigmatizing and being excluded from decent society. And the fact that judges are no different than anybody else, they live in Washington, this judge lives in Washington, the one supervising this process, makes her highly susceptible to that as well. And one of the things that happened was the gag order that Jack Smith prosecutors wanted had to be justified. Why is it necessary to conceal from Donald Trump the fact that this information is being sought? Why can't you give him the opportunity to have his lawyers come into court and object to these requests? They had to justify why it was dangerous to allow him to find out. And because this is something the FBI frequently does, the Justice Department has kind of forms where they just stick in various paragraphs that they always include to justify gag orders. They have maybe 8 or 10 different arguments for why a gag order is appropriate. One of them that they often use is that there's a high risk that the defendant would flee if they learn they're being investigated. And the Justice Department included that paragraph, that form paragraph, in its brief to the judge, arguing why the defendant in this case, the target of the investigation, Donald Trump, could not be notified. And they claimed that Trump was a high risk of fleeing, that he would leave the United States if he knew he was being investigated. Even though everybody knew Donald Trump was being criminally investigated, they were talking about it openly. He's surrounded by Secret Service. He obviously hasn't left the country, despite having learned many times that he's being investigated. It's such a preposterous argument that After the Justice Department submitted it and it went to appeal, they said, look, we withdraw that. We didn't intend to include that. That's how ridiculous it was. But the judge in the case accepted that reasoning when imposing the gag order, even though the Justice Department ended up admitting that it's so ludicrous that they didn't even mean to include it, they said. So here you see the appellate court ruling that actually reversed some of the district court's rationale, but upheld a lot of the rights of the prosecutor to obtain this information. And there you see in the highlighted paragraph the following, quote, the district court also found reason to believe that the former president would, quote, flee from prosecution. That was part of the district court's ruling. This is the appellate court. The government later acknowledged, however, that it had, quote, errantly included flight from prosecution as a predicate in its application. They do say the district court did not rely on risk of flight in its ultimate analysis, but they did end up accepting that Trump was a risk to flee, even though the Justice Department ended up claiming that they actually ignored it. There you see Michael Tracy's tweet on this, quote, amazing, Jack Smith tried to impose a gag order on Twitter by arguing Trump was likely to, quote, flee from prosecution if it came out that his account had been seized. DC District Court then affirmed the validity of this claim. Later, the claim was mysteriously retracted as errant. That doesn't create a lot of confidence that this case is being judicially shepherded with objectivity or competence, does it? The fact that a claim the Justice Department was too embarrassed to maintain on appeal was one the district court ended up crediting. That Donald Trump is a flight risk. We've been through all the arguments about why these indictments are so dangerous, why they're legally dubious. The best of the cases so far is the one in Mar-a-Lago about the documents, but that is preposterous. The idea that people go to prison for recklessly maintaining classified documents when they leak it every day, including the people who go on TV acting indignant about what Trump did here. But that is the best of the case. This latest indictment is a joke. But if you're going to, as I said, allow these indictments to proceed, and if you're going to indict the person who was formerly president of the United States and then try and convict them, even when they're leading polls as the presidential frontrunner, you better make sure that process is clean. This is a very bad start to providing that confidence. Thanks for watching this clip from System Update, our live show that airs every Monday through Friday at 7 p.m. Eastern, exclusively on Rumble. You can catch the full nightly shows live or view the backlog of episodes for free on our Rumble page. You can also find full episodes the morning after they air across all major podcasting platforms, including Spotify and Apple. All the information you need is linked below. We hope to see you there.